Good morning. Thank you all for joining us. My name is Seth Maskett. I'm a professor of political science and director of the Center on American Politics here at the University of Denver. The Center on American Politics is now part of the Scribner Institute of Public Policy here within the Korbel School of International Studies. This is the first event we've done for the 2021-22 academic year. Thanks to all of you who have joined us in the past, and welcome to all of you who are new to these events. We have a number of things planned out for the rest of the year. Both in-person and online formats. We'll be covering topics like the health of American democracy, women's rights and political engagement, Native Americans in the petroleum industry. We'll be partnering with Korbel on the Denver Democracy Summit and more. One of the things we like to do with the Center on American Politics is put together discussions in fairly short timeframes to discuss crucial current events as they're emerging. Scholarship at the speed of news, if you will. Given recent developments in Texas, particularly with the recent Supreme Court case over their SB 8 abortion restriction bill, we felt it was important to bring together a group to discuss what this all means. I'm grateful to our panelists today for being willing to do this on such short notice. To briefly summarize what happened, the Texas legislature in the spring passed SB 8, the so-called Texas Heartbeat Bill, which bans abortions after 6 weeks of gestation. This is, of course, sooner than many people even know that they're pregnant. The law also empowers Texas residents to sue those who provide or abet abortions, who can receive up to $10,000 for doing so. Governor Abbott signed this bill into law back in May. It went into effect at the beginning of this month. An injunction was attempted to keep it from going into effect, but in a late night ruling last week, the US Supreme Court denied that motion on a 5-4 vote. Since that time, several other states have expressed interest in following Texas's path. With most abortions now functionally banned in Texas, and with the Supreme Court's apparent blessing, Roe v. Wade has arguably been overturned, which will have enormous consequences across the country. This is what we're here to discuss today. I want to start by introducing our panelists. First, Amanda Hollis-Brusky is chair of the politics department at Pomona College. She teaches and researches on American politics, constitutional law, and legal institutions. She comments frequently on the politics of the Supreme Court at prominent outlets like NPR, The New Yorker, The Los Angeles Times, and more. She's the author of Ideas with Consequences, The Federalist Society and the Conservative Counter-Revolution. She is also a co-author of the recent book, Separate but Faithful, The Christian Right's Radical Struggle to Transform Law and Legal Culture. She wrote that book with our second panelist, who is Josh Wilson. Josh is chair of the political science department here at the University of Denver. His work lies at the intersection of politics and law. He does a great deal of public scholarship as well, writing for Newsweek, Time, The Washington Post, and elsewhere. He's the author of 2 books on abortion politics, including The Street Politics of Abortion, Speech, Violence, and America's Culture Wars, and is also an associate editor with the Law and Policy Journal. Finally, we have with us Ian Farrell, who is an associate professor at DU's Sturm College of Law. His scholarship and teaching interests converge on criminal law and procedure, constitutional law, and the philosophy of law. His work has appeared in the William and Mary Law Review, the Texas Law Review, the Villanova Law Review, and others. So here's how this will work. I'm going to ask several questions of our panelists over the next half hour or so. And then, time permitting, we will turn to your questions in our audience. If you have a question for our panel at any point, please type that question in using the Q&A feature that appears at the bottom of your Zoom screen. I'll be going through those and reading your answers and trying to get some answers for you. We'll do our best to get through as many of your questions as we can. By the way, this session is being recorded. It should be available within a few days on the Center on American Politics website. That's du.edu/American Politics. So now for our questions, I'd like to start by asking Amanda a question. Amanda, several conservative states have attempted drastic restrictions on abortion rights in the past, but those have rarely gotten very far. The US Supreme Court has usually dismissed those out of hand. I'd like to just get a sense from you, what's different about this time? Why is the court permitting Texas's law?
Thank you, Seth. Thank you for having me. So I think in order to understand where we are, it's important to have a brief history of what the law of abortion has looked like in the United States. So when we think of abortion, we think of the landmark ruling in Roe versus Wade, the 1973 ruling, which found a constitutionally protected right for a woman to seek an abortion. That opinion was deeply informed by medicine, deeply informed by science. Harry Blackman writes an opinion in which he argues that there's sort of the 3-trimester framework. In the first trimester, a woman's right to seek an abortion was virtually unrestricted, right? And that lasts about 12 weeks. In the second trimester, the state could regulate a woman's right to seek an abortion, but those regulations had to be pursuant to the health and safety of the woman. Now, in the third trimester, past what is known as the viability point, that's the point at which medically, scientifically, the fetus could conceivably live outside of the womb. The state could put more regulations and could even outright ban abortion at that point. That kind of rigid trimester framework was in place for almost 20 years until in 1992, the Supreme Court heard a case called Planned Parenthood versus Casey. In that ruling, Republican appointees Sandra Day O'Connor, Anthony Kennedy, and even David Souter joined the liberal majority to uphold the core of Roe, right? They reinforced that a woman does have a constitutionally protected right to seek an abortion, but they scrapped the rigid trimester framework in favor of what's known as the undue burden standard. So a woman had a right to seek an abortion, but the state also had a right to regulate that process and that procedure and that right, as long as those regulations did not place an undue burden on the woman seeking an abortion. And so as Josh writes about in his book, The New States of Abortion Politics, states began experimenting with different kinds of legislation and regulation. Well, is a 72-hour waiting period an undue burden? Is parental notification an undue burden? Is spousal notification an undue burden? They also began experimenting with what's known as trap laws, the targeted regulation of abortion providers. So instead of regulating the woman directly, they would regulate the environment and the facilities in which she would have an abortion. And they started playing around with these. And the Supreme Court has upheld some of them historically and struck down others. Now, the one thing that does remain from Roe, which really is at stake right now, is the viability line. So the viability line has been used as a pretty clear marker of when a state can outright ban abortion and when they can't. Right now, there's a case before the Supreme Court called Dobbs, Jackson's Whole Woman Health, which is the only abortion provider in Mississippi, is challenging a law that is outright banning abortion at 15 weeks. This is before what we would consider the viability line. So this is a direct challenge to Roe and Casey. That case was re-petitioned 12 times by the Supreme Court in conference before they finally decided to take it up. So they'll be hearing a challenge at the heart of Planned Parenthood versus Casey and Roe this term. The Texas Heartbeat Bill, this is a league unto itself, right? What Texas is arguing, they're not striking at the woman and her right, and that is at the core of Roe and Casey. What they're trying to do is create a series of legal landmines that anyone who helps facilitate information or provide services for a woman seeking abortion is going to be held liable for those actions. And so, as Seth mentioned, the law creates a $10,000 incentive for anyone in Texas to report any activity of people helping, aiding, and abetting a woman seeking an abortion after the 6-week mark. This is striking, it's remarkable, and it's going to create a legal morass for women in Texas and abortion providers, medical providers. Doctors are not going to know what they're going to be able to tell women about abortion without the fear of being sued. And so this is really what's different about the Texas law. And as you mentioned, Seth, other states may start taking up the same kind of legislation to create confusion and to discourage women from seeking abortion and exercising their constitutionally protected right in Texas.
Thanks so much. That was a really helpful explanation of a lot of things going on in this bill. Josh, I would like to turn to you on that last point that Amanda was mentioning, the essentially the enforcement mechanism. I know you recently wrote a very popular piece on this. This enforcement mechanism, where instead of having police enforce the law, the law essentially deputizes Texans to identify and sue those who aid and abet abortions. Where does this idea come from? Was this invented, completely out of whole cloth? Why did they choose it in this case?
Yeah, no, thanks, and thanks for having me on the panel. The law it's simultaneously incredibly novel, but also somewhat familiar. But it takes what is familiar and changes it in some really important ways. And so this law has a lineage. This is kind of this enforcement mechanism by taking the state out of enforcement and deputizing individuals, specifically non-state actors, to enforce the law has its own lineage. And it's basically what we can see in US politics when the state has limited power. So one of the places that we can think about this originally is on the other end of the political spectrum, is with progressives and things like civil rights, and then after that, in an ever increasing range of regulatory areas. But I'll give you a little bit of background here and then kind of walk you forward to show you what's familiar and also what's different about SB 8, the Texas law. So when progressives were wanting to pass civil rights laws and other related legislation in the mid-20th century, they really wanted the federal government to be the enforcer of these rights and to have this kind of robust federal enforcement mechanism. But they ran into barriers via conservatives both in the Republican Party and in the Democratic Party. And their objections were somewhat about kind of the growth of the state, but also about wanting to essentially blunt the rights that progressives were pushing. And so essentially the compromise that was reached was that instead of having a robust state enforcement mechanism here, that individuals would be allowed to sue to enforce these rights. And the thinking, like I said, was that, for conservatives at least, was that this would really blunt the ability to enforce these rights, because it was thought that a lot of the people that stood to benefit from these rights didn't have the legal resources to enforce them on their own without the federal government stepping in on their behalf. To everybody's surprise, both progressives and conservatives, there was what Chuck Epp, who's at Kansas, calls a robust support structure that was developed. So that's a whole network of lawyers and funding mechanisms that allowed people to pursue private enforcement of these rights. And so it became this more robust enforcement mechanism, and thus began to spread to a bunch of different policy areas for progressives. And as kind of an irony here is, as conservatives saw that develop, they started working to dismantle private enforcement mechanisms. But let's kind of move ahead here to today. Abortion is really marked by experimenting and recycling strategies. And so, as Amanda said, right, we can, and Mary Ziegler, who's at Florida State University, writes some really great histories on this, of how you can see a lot of strategies that come up, first appearing decades before, failing, and then kind of re-emerging later. This one, though, the private enforcement mechanism, is kind of a newer innovation within abortion politics. And what they're doing, right, is they're running against what Amanda laid out with Casey and the viability standard. The state can't enforce bans on abortion before viability, so roughly around 24 weeks. What this law does is it moves it back to 6 weeks. So it cuts 18 weeks out of that period that the state is not allowed to enter, right? And it does that by running essentially behind private enforcement, saying the state's not involved, private individuals can enforce this, right? So this is, like I said before, we see these private enforcement mechanisms emerge when the state doesn't have capacity to act. Texas, as a conservative state wanting to ban abortion, is limited by Supreme Court precedent. And so it's taken this novel move of pivoting towards private enforcement, where we typically see state enforcement. And just a couple things to point out, right? So while we can see this private enforcement lineage, the aim here is very different from how we've seen it used for many decades. It's also very different in how open it is in who can litigate. With civil rights or labor law or health enforcement, you have to be specifically harmed in order to enforce the law. Here, you don't. And every Texas citizen or every person is deputized, as long as they don't work for the state government, is deputized to bring suit in court. So it's very different in the aim, it's very different in that mechanism. But it's familiar in terms of relying on private enforcement. It's also familiar in terms of the state creating incentives to create private enforcement. So we brought up the $10,000. What you stand to gain is actually a minimum of $10,000. You can gain above that. If you win, you also get your legal fees back. But if you're sued, you can't recoup your legal fees. So there's even an incentive there to bring suit, even if you're going to fail, because you're still costing money to abortion providers and abortion supporters, and costing time and emotional energy and so forth. And then the last thing that's kind of similar here is, I said progressives came to gravitate towards these kinds of private enforcements because they learned that they had this robust support structure of lawyers who could litigate on their behalf. Conservatives didn't used to have that. Conservatives have developed that over the last few decades. And so that's one of these things that now makes this type of private enforcement more attractive for conservatives, whereas we see a much longer history of them fighting private enforcement mechanisms.
Thanks, that was really helpful. Ian, I'd like to turn to you. There's a topic that has come up a lot with this, is that saying that this Supreme Court decision was decided on the quote unquote shadow docket. That term gets thrown around a lot in the news without ever really explaining what it is. And I wonder if you could give us a little bit of an idea of what that means, what the shadow docket is, and what are the consequences of that, as opposed to deciding it through its more typical process.
Thanks, Seth. That's a great question. The term shadow docket is a new term for something that's been around for a long time but has recently gained additional prominence. So the idea is that the court has its sort of usual docket where it decides cases on the merits. And so that's a situation where, for instance, in this case, the challenges of the Texas heartbeat law sue in a trial court, it goes up to an appeal court, and it goes to the Supreme Court. There's potentially years for people on both sides, and also people who are interested in the form of amicus briefs to develop arguments for why it should either be upheld or not upheld. There is extensive oral arguments, and so when addressing the merits in the normal mechanisms of the Supreme Court, the court is given a huge amount of support and information and time to allow them to come to a reasoned decision. The shadow docket is the set of cases where the court is asked to act quickly. So they're emergency petitions, and they're often, like in this case, interlocutory appeals. And so what that means is there are appeals that are going to the Supreme Court quickly while the other process is going along. And so that's important, especially in this case, to understand what exactly the court has done and what it hasn't done. So what happened in this case is that a group of abortion providers challenged the Texas law, and a hearing date was set essentially for a trial. But then the Ninth Circuit Court of Appeals basically got rid of the hearing date and said that the law could come into effect on September 1st. And so the actual decision on whether this law is unconstitutional has not been heard yet. Instead, what the court has heard is, what should we do in the meantime? What should the law be for the maybe 2 years while this is argued? And so the the challengers argued that we should have the status quo. We should have what the law was prior to this act coming into play continue until we've verified that this law is constitutionally permissible. Whereas the state has said, no, this law was enacted by the legislature. And so absent a successful, or until there's a successful constitutional challenge, then we should allow the law to be enforced. And that's the decision that the court made. So the court expressly said, we're not deciding the ultimate constitutional question here. But of course, our decision as to whether or not to allow the injunction is in part dependent on the likelihood of success of that constitutional challenge going forward. And so in this case, the court said that the law will go in force up to if and when it is successfully challenged. In other words, when this decision actually gets completely resolved by the Supreme Court. Now, in general, with the shadow docket, a couple of things have happened with the shadow docket in recent years, primarily since the beginning of the Trump administration, and that is that shadow docket decisions have been far more common, but they've also been, in my view and in the view of some other scholars, more aggressive, and they've been less consistent, right? So there are plenty of other cases we can point to, especially, for example, the COVID bans that were in fact enjoined by the Supreme Court on the shadow docket, where if you look at the rules that the court is supposed to be applying, the Texas case should have been stayed and the other cases should have been allowed to move forward. And so there's a real concern here that the shadow docket is being used in a way that's inconsistent. Another problem is that the court does not have to give reasons for its decisions on the shadow docket. So in this case, the majority opinion, which was unsigned, by the way, the only way we know who was in the majority is because there were 4 dissenting judges who all filed a dissent. And so there was a very, very brief statement of the reason for why they refused to stay the law. And another thing with the shadow docket generally is that the Supreme Court is, for the first time, starting to act as though the decisions on the shadow docket are precedents that other courts, lower courts, have to follow. And so all of those sort of generally are concerns with the shadow docket. One thing that's worth pointing out, and I think this really connects to a couple of things that both Amanda and Josh have said, is that one of the reasons why, excuse me, Texas is employing this private individual enforcement mechanism is to create procedural problems with suing to challenge the law. And those are exactly the issues that the Supreme Court pointed to as reasons why they didn't stay the law, right? So there's this thing called sovereign immunity, which means that in general, you can't just sue the state of Texas. So instead, if you want to challenge a law as unconstitutional, you would sue the people who are tasked with enforcing it. So normally you can sue to have the statute struck down before anyone's even been sued under it, right? By suing the Attorney General, for instance, right? Let's call it the perverted genius of this approach is that it takes away a target for anyone to sue. And so that's the main reason why it's been, it hasn't been struck down until this point. Because you can't just sue like every person in the state of Texas to prevent them from suing you in the future.
Can I add to that really briefly?
Sure.
So, and this also, I think, if we pivot here to kind of a abortion politics strategy perspective, this ruling actually puts anti-abortion activists in a little bit of a bind, because what the court has said in part of its listing of how the claimants in the case haven't reached kind of a significant enough standard to enjoin the law, their last argument is, they say, the sole private citizen respondent before us has filed an affidavit stating that he has no present intent to enforce the law. So they're basically saying, we can't do anything until somebody actually files a lawsuit under SB 8 against an abortion provider or against somebody seen as aiding and abetting an abortion after 6 weeks. So that creates a strange bind for anti-abortion activists who want to use this law, right? It gives them this new, very powerful coercive tool that they can use. But they have also been told by essentially their supporters in the Supreme Court that if they use this law, it'll trigger constitutional review of it. And so they're in this weird space in between where they want to use the law, but if they use it, that could lead to removing this law. So it might be best for them to not act on the law and just let it have the chilling effect it's having right now in Texas hold. Because right now it's effectively stopping abortions after the 6th week. And so we've got to see what happens here as well, right? Does anybody actually sue under SB 8, or do they try to just let it hold balance and chill abortions for as long as possible as litigation moves forward? And we can kind of look backwards here too. The last time Texas was in the news in the Supreme Court about abortion politics with the whole women's health case, right? We also saw that there's a case about a trap law that Amanda described earlier, and the time that it took to strike down that law allowed enough time for clinics to close. And so activists in Texas are also familiar with, if you just let the court take its time, even if the law gets struck down, it can have the corrosive effect that they want it to have.
Thanks for expanding on that, Josh. Amanda, I have a question for you. Just beyond abortion specifically, we've seen a lot of legislative activity in Texas recently, including in areas like new voting restrictions, including expanding gun rights. And I'm curious, are these all connected basically? Is this an overall conservative legal strategy, or is this just sort of, a legislature just, doing kind of a kitchen sink approach? Why is all this happening apparently right now?
Yeah, that's a great question. So for me, thinking about, in particular, the new voting rights bill that the governor signed, I think yesterday, SB 1 and SB 8, these seem to have quite a bit in common. So what's going on in the voting rights bill? Like SB 8, SB 1 is removing a lot of expanded ballot access that was a result of the coronavirus pandemic. So mail-in balloting, 24-hour access to polling places, things that were done in response to the coronavirus pandemic that other states have adopted as more permanent changes, those who want to expand the right to vote and ensure greater access to the ballot. Well, in Texas, like in many conservative states right now, there's a wave of voting restrictions bills happening throughout the country that are undoing a lot of the expansion that was done on account of the pandemic. But Texas, as it is wont to do, is taking it even further. So in addition to removing the provisions that expanded access to the ballot, Texas has implemented a series of criminal sanctions for anyone who helps, sounds familiar, aids or abets anyone else in exercising their right to vote, but does not follow these series of hurdles that Texas has put in place for anyone who wants to legitimately help somebody else to vote. So in the past, people have, particularly with language barriers, folks have been allowed into the polling place to help read, translate. Folks have been allowed to help deliver, right, harvest ballots and bring them to the polling place for folks who have issues with access to transportation or other reasons they can't access polling place. And what Texas has said is, unless you go through these 75 procedures to get deputized by the state and swear an oath, you can't help anyone else vote. right? So you cannot help anyone else. And if you do, you will be subject to criminal sanctions, not just civil penalties, criminal sanctions, right? This, like SB8, is creating a series of legal landmines for folks who want to exercise their own constitutionally protected right to vote, but in particular for folks who want to help others exercise their constitutionally protected right to vote. Seth, because you're here, I couldn't help but drawing the comparison to Indiana Jones and the Temple of Doom, right? It's going to be extraordinarily difficult to get through the Temple of Doom without stepping on the wrong rune, right? Without, there could be a giant boulder coming after you, the whole thing could collapse. And unless you are someone like Indiana Jones, who's extraordinarily sophisticated, knowledgeable, and clearly physically agile, it's going to be hard for you to navigate this new legal morass. And the intent here is the exact same intent with SB8, is Texas hopes that if they make it so complicated, you'll just stay home. You won't vote and you won't try to seek an abortion. So to me, there are some strong parallels between those two provisions in particular.
Thanks. That's better than Temple of the Crystal Skull, I suppose. Okay, thank you for that. We actually have a number of questions from our audience. I'd like to turn to a few of those now. Here's a question from Chris. Basically, could Congress, as a response to what Texas has been doing, could they pass simply a right to abortion? Just simple by majority. If it did, would that pass constitutional muster with regard to the 10th Amendment? What are the pluses and minuses of doing that approach? I'm not sure who'd like to answer that question.
I can take a stab at that. So the first thing that the law would have to satisfy is a basis for Congress is the federal government is a government of enumerated limited powers, and so the first question would be, what is the source of the power? One possibility would be the Commerce Clause. That's sort of the main source of federal power, and another would be the enforcement mechanism of the 14th Amendment. So the 14th Amendment not only provides for things like the right to equal protection of the laws and the right to due process, but it also allows Congress to pass laws in order to enforce that right. The main problem there, I think, would be the problem that, like, it's the big elephant in the room right now, which is, does the current majority of the Supreme Court believe there is a right to abortion in the Constitution? And so I think the ultimate question here is that question, right? So that's the question that, as Amanda pointed out earlier, will first be directly addressed by the court in a merits decision in the Mississippi case this term. And like everything really turns on that, right? If the court in that case says that it is not a violation of the Constitution to prohibit an abortion before 22 weeks, whether it be 15 weeks or 6 weeks, then one, Texas and other states won't need these fancy procedural mechanisms of giving individuals the right to enforce. They can just enforce. And secondly, if the federal government would then try to intervene and try to protect abortion, there is a potential argument that it's outside of their powers, especially the 14th Amendment enforcement power.
Yeah, and I would just jump in here to talk specifically about the Commerce Clause. Think about the Affordable Care Act. The government thought they were on pretty solid footing, passing the Affordable Care Act, requiring individuals to purchase health insurance, because healthcare is an issue that affects interstate commerce. There's no ifs, ands, or buts about it, right? We have a sort of private insurance scheme, which is interstate, and healthcare costs are dependent on healthcare expenditures, not just within a whole state, but across the country. So what happens in Texas does affect healthcare prices in California and Minnesota and Massachusetts. And yet the Supreme Court still found there go my lights, right? The Supreme Court still found that this was beyond commerce, the Congress's commerce power. This is not an issue of interstate commerce. And it was upheld because John Roberts joined the liberals and said, well, let's just call it a tax then. So if the Affordable Care Act can't stand constitutional scrutiny as sort of influencing commerce among the several states, it's highly unlikely that a conservative majority on the Supreme Court is going to find a right for Congress to regulate abortion specifically under that same power.
I'm going to add in one other thing here too, to kind of pick up on the politics side of this as well. It's interesting to see in the ruling here about SB 8 that we have so far, the split that we have with Roberts siding with the progressive justices, where we have Thomas, Alito, Gorsuch, Kavanaugh, and Coney Barrett, not signing, but clearly writing the majority opinion here. One of the things that struck me from this is the internal division that's happening within the court, that Roberts signaled not all that long ago in June Medical Services, a case out of Louisiana. He put out a pretty big signal of how I think he would like to see anti-abortion activists move forward with litigation. So again, a slower, incremental process of chipping away at abortion rights. And this fits with a lot of what what's commonly said about Roberts of, he is the Chief Justice. This is his court. It is named for him. And he is thus self-conscious or conscious of wanting to preserve the legitimacy of the court, right? Not wanting it to be seen as taking dramatic political moves, right? And what struck me here in this is how he's siding with the progressives. He calls the law unprecedented, right? Sotomayor comes out and calls it flagrantly unconstitutional. Kagan specifically quotes the term shadow docket as a way, and all these things are signaling to the majority, you are threatening the legitimacy of our court. But those other 5 justices have not been swayed, right? I want to say that Sotomayor says that they're, sticking their heads in the sand, right? That they're basically willfully blinding themselves to the reality of a situation here. And so we're seeing a really big divide, and the great significance of Trump's reformulation of the Supreme Court to make conservatives not have to rely on Roberts. And so I'm really curious to see, and this is the reason why this relates to this question, is about how far is the court majority, this 5-justice conservative majority, willing to go to really move aggressively against abortion? And that then has these ramifications for what would happen if Congress were to act. How will this court act in response?
Yeah, I just want to add a couple of things. I completely agree with everything that was just said. And I like the comparison with the Affordable Care Act, right? So the possibility of an abortion prohibition being found to be within the Commerce Clause power has a better chance and a worse chance in different ways compared to the Affordable Care Act. The reason the Affordable Care Act was held to not be part of the Commerce Clause is because it was mandating that people do something rather than prohibiting something. However, as Amanda really nicely put it, the degree to which the Affordable Care Act affected interstate commerce was vastly larger than the prohibition on abortion would affect interstate commerce. So that's the way in which it would be more difficult to bring a claim that it's under the Commerce Clause. And the reference to Chief Justice Roberts is crucial here, right? The understanding most people have of what happened with the Affordable Care Act case was that Roberts basically switched his view at the last minute and thereby infuriated the other conservatives, especially at the time, Justice Scalia. And he did that precisely because he didn't want the court to be appearing to be a purely partisan institution. And I think that's still going on here. But as Josh said, the difference is there are 5 far more conservative justices who don't seem to care. And this connects back to the shadow docket versus the ultimate decision here. There is a very strong signal being given by the conservative majority that they are very much inclined to make relatively radical decisions and potentially do something like completely and unequivocally overturn Roe and Casey.
Yeah, and I'll just, as a reminder, if you haven't heard about it yet, there is a commission on Supreme Court reform, but they're calling Biden's bluff. They don't see Biden and the Democrats as willing to blow up the filibuster and put through a package of radical Supreme Court reforms, including adding seats to the high court that Biden could fill. And so to piggyback on Ian's point, there are at least 5 justices on the court who are calling his bluff and saying, we don't care if we're perceived as illegitimate, because we actually don't think the Democrats are going to do anything about it. And I think Roberts is still very much concerned with the imagery of the court.
Yeah, and think about what the court could do if it wanted to, right? It could say there's no right to abortion. It could say there's no such thing as fundamental rights at all because they're not in the text of the Constitution. So that would get rid of a lot of, like a huge amount of individual rights. They could say the Bill of Rights doesn't apply to the states, right? Originally, it didn't apply to the states. It was only when the Warren Court incorporated it through the Due Process Clause of the 14th Amendment. And that
Except
would
for the Second Amendment.
Right.
They want that one to apply to the states.
Yeah, well, that's right, exactly. And so, the stakes here are just extraordinarily high. And I think that reinforces Amanda's point about whether the Democrats in Congress and Biden should seriously consider drastic court reform.
So, I'm sorry, I know that we're going off on this one question, but this naturally, I think, leads to the other point too of, all right, I agree that the 5 justice majority is calling Biden's bluff, but so if we look beyond the court at a wider political context, the last 4 years, and I feel like this is just adding to this, is making the court a way more salient issue for Democratic voters. The Christian right has long been able to rally behind voting rally their base and rally their voters in the name of affecting the court. Progressives have been very bad at doing that. This has just been a low salience issue for Democratic voters, as has abortion, actually. What we can see over the last 4 years, during the Trump administration, public polling data showed that abortion began to rise in the ranks of issues of most concern for Democratic voters. What this also adds to is the Trump years and now this are all, I would argue, building the saliency of the court as a voting issue for Democrats. And so as a way of then kind of mobilizing voters and then maybe mobilizing moderates as well, because we know from public opinion polling data, specifically about abortion, the majority of the US populace does not want to see abortion made illegal, right? They're somewhere in the middle. And so this all adds to the ability to mobilize those voters, right? And so if we look ahead to elections, Republicans have had problems in the suburbs. This stands to maybe hurt their prospects again in those suburbs, right? As we increase the salience of the court and increase the salience of abortion politics.
Okay, thank you for all that. I'd like to, we have a question that came in that's related to that last question. And Amanda, I'd like to start with you on this one. This is coming from Cynthia. We're hearing reports that the Department of Justice may take action in Texas to protect women's abortion rights. What kind of actions can we expect to see them take? We just what options does justice have? Do they have any likelihood of success?
I don't think so. From my understanding of what they're capable of doing, as Ian laid out, the procedural mechanism, which he called, a stroke of perverted genius, makes it very difficult to identify anyone, right, who could, outside of the state, right, who could be sued in this case. So again, from my perspective, there aren't a whole host of federal laws that Merrick Garland as we're talking about court reform, the now Attorney General, can sort of pursue, but maybe Ian knows better.
Yeah, no, I agree with that. So the specific procedural mechanism or the specific claim that the Attorney General is referring to is it's actually a criminal offense under federal law to violate someone's constitutional rights under color of law. So assuming that we have remaining Roe and Casey, so that it is a violation of a woman's constitutional rights to have her access to abortion before 22, 24 weeks prohibited, to interfere with that is a federal crime. But as Amanda points out, we can't use that until someone actually does it, right? And this connects very well with Josh's fantastic point earlier, which is this may just be a delaying mechanism, and it is still successful if it delays long enough that abortion clinics have to close. And so Merrick Garland's hands are tied until at least the point at which somebody sues. And it could be that if somebody sues in Texas and then the Attorney General charges them, they could argue in their defense that Roe and Casey are unconstitutional or wrongly decided. But it's a great question.
Thanks. Another question that came in more specifically about SB 8 from Claire. What are people's options in Texas if they're seeking an abortion after 6 weeks? Is it possible that providers will not enforce the law? Is that too big of a risk for them? What options do people have there?
Yeah, I just want to jump in because I was recently reading some figures from Guttmacher, and Josh mentioned earlier when the litigation against Whole Woman's Health was going on, abortion clinics were in this sort of realm of legal uncertainty, were forced to shutter their doors. Many of them have not reopened. And so there was some figure about the average woman in the state of Texas right now, after 6 weeks, if they realize they're pregnant, which almost every woman realizes after this point, would have to travel an average of 447 miles round trip to access the right to an abortion. Now, we don't know under the statute, because the language is so vague, whether anyone who drove her out of state and back could be liable to be sued under this statute. And so, again, it's a realm of legal uncertainty that is only going to be sort of hashed out as lawsuits begin. And the second thing I'll say to that is there was a district court, trial court level in Texas that did block a lawsuit against Planned Parenthood and threw it out. So remember, we have federal courts, but we also have state courts. And so state courts in Texas are beginning to hear some of these suits. And it's important to keep in mind that in Texas, judges are elected, and they're elected in partisan elections as Democrats or Republicans. And what we could start to see is people throwing, Democratic judges in Texas throwing these suits out, and Republican judges in Texas letting them go forward. So it creates, again, another kind of layer of judicial federalism and confusion. But the bottom line is women in Texas are the ones who are suffering right now.
Yeah. And to just kind of go back to this question as well, right? The option right now is to leave. And that's not an option for many people, first off. The second is, if this legislation basically spreads, it's going to spread to many of the neighboring states of Texas, which makes leaving all the harder, right? Is if you lose Oklahoma and Louisiana, right? New Mexico, you probably won't lose, but still, right? Texas is a huge state. And so that's going to increase the area of travel, which increase costs, right? Other things to consider about this too. One is health outcomes, right? What's going to start happening with women's health outcomes as Texas effectively takes abortion after 6 weeks off the table? And then if we go on, and we need to consider that in two ways. One is the effect that has on women themselves. The other is the effect that has on the politics of abortion, right? Because health outcomes are actually what drove the liberalization of abortion laws in the mid 20th century, right? And so we can kind of be returning to seeing how health outcomes matter politically. The last one, this is just me thinking off the top of my head, listening to Amanda's response here, and also thinking about the question is, to go back to the point earlier of the court has said, we can't really act on this until somebody uses the law. Well, does some clinic muster enough resources to say, we're going to call your bluff and we'll start providing abortions again? We'll see if that triggers lawsuits and see what happens. I haven't given that one much thought. Like I said, that just popped into my head listening to Amanda here.
Yeah, that's the thought I had after listening to Amanda as well. But as Josh pointed out earlier, that's hugely risky, right? You're setting yourself up for legal liability if you lose, not just for the at least $10,000 per abortion, but also legal costs and fees, which can be a lot. And the other thing to say here is, and I'm sure everyone listening is already aware of this, and this connects to what Josh was saying about health outcomes, right? Making abortions illegal doesn't stop abortions, right? It just means that they take place in situations where it's less safe for the women involved.
Thank you for all this. Had a question here from Frank, and this touches on something Josh had said earlier, just noting that under the Texas law, people who do not suffer direct harm can sue. Assuming this holds and this becomes some sort of precedent, what sort of can of worms does this open, among other issues? We could see a situation where in California, random citizens can sue people who don't wear masks, or you could sue in Colorado if someone litters on I-70 or something like that. What does this potentially open up, and will this hold?
Yeah, sorry, Josh.
No,
I was going to jump in and say, the minute this bill was signed into law or went into effect, you had folks on the left saying, okay, California, let's get on guns, right? Okay, Massachusetts, let's get on anti-vaxxers and anti-maskers. This, to me, creates a very dystopian future. We're already, and Seth could speak to this better than any of us here, more polarized than we've been in hundreds of years, politically, socially, and ideologically sorted. And now what we would be is a series of blue states enacting civil penalties against citizens trying to exercise their constitutional rights that we don't like, and a series of red states enacting civil penalties to disincentivize or prevent citizens from enacting their constitutional rights that we don't like. We cease to be a union under a federal constitution that's supposed to provide a floor of rights for everyone, when states can creatively find workarounds to prevent their citizens from accessing the rights that they don't like. So this, to me, is a nightmare scenario. It's not one of these situations where I would encourage the left to rip a page from the playbook, because this is, a nightmare for the rule of law and a nightmare for, the Constitution as a document that's supposed to provide, regardless of accident of birth, a floor of rights for everybody.
What that triggers in my head is, and bear with me for a moment here, but I oftentimes go back to Max Weber. And one of the things thinking about with Max Weber is, right, the primary role of the state, of government, is to monopolize the legitimate use of violence, right? To take violence and coercion out of the public's hands, endow it in the state, and then restrain the state in its use, right? And that makes everybody safer. And so if we just change that language from violence to coercion, what Texas is doing here is relinquishing its monopoly on coercive power. And not just that, it's handing over the instruments of coercion to the public to use how it wants to. And, so it's essentially removing the state there. And we endow the state with that responsibility, with that duty, for a reason. And as Weber argues, it's like the primary reason why we have states. And so that's kind of a theory way of getting at what's so potentially dangerous about laws like this is that we're essentially releasing the monopoly that the state has on various forms of coercion. And then not just giving it to the public, but creating incentives for them to then use it.
Yeah, I have two things to say, sort of following up on what Amanda and Josh both said. I love the phrase dystopian, right? And as Amanda pointed out, one of the examples that people have been raising is, what if we gave Californian citizens the power to enforce gun restriction? The really dystopian example that has come to my mind is the cruel and unusual punishment clause of the 8th Amendment prohibits juveniles from being executed, right? So what if the state of Texas said, okay, fine, we won't execute anyone, but we'll offer $10,000 plus immunity to anyone who shoots in the head, like a juvenile who's been convicted of murder, right? So dystopian and nightmare and so forth, I think, are appropriate words for where this could go if this stands. But that's the second thing I want to say, which is I don't think it will survive precisely because of the standing requirements. So in federal court and in state courts, you can only sue if you have the requisite standing. In federal court, that means, among other things, that you have to have shown a material injury. The standing requirements in state courts vary from state to state, but as it happens, the standing requirements in Texas basically follow the federal law, right? So on its surface, it would seem as though this law would not survive a standing challenge because it's different from, as Josh pointed out earlier, the civil rights legislation where citizens can only sue if they themselves have been harmed. There is a wrinkle, however, and that is that there's an even older and weirder set of laws called qui tam laws. They've been in the federal legislation since like the 1860s. They go back to the 13th century in England. And they were one of the inspirations for the Texas lawyers who came up with this approach. And what qui tam laws do is they say the state can sue, but so can any individual. And an individual can sue on our behalf. And if they win, they get like 25 to 30% of the profits. And so anyone can sue, even if the person has not been harmed. Whether people had standing there was an issue that was unresolved for a long time. But about 20 years ago, the US Supreme Court said that the qui tam civil actions give every citizen standing. And so the question, as sort of from a technical legal perspective, is would the same decision apply to these laws that are in some ways similar, but in important ways different from the qui tam laws? My argument is no, because the court specifically said qui tam laws give standing, not because of the potential of getting money at the end, but rather because the state is assigning its interest in the case that it could litigate to an individual, whereas under the Texas law, the state is prohibited from ever litigating it. So I don't think the argument would apply. Does that mean I'm confident that a Texas court or the US Supreme Court would agree with me? No, right? There is enough room and complication there that it could go the other way. But I think that's a perfectly plausible argument.
Thank you. We're actually just about out of time. So I really appreciate that there's some excellent questions that came in. Thank you for those. If you did not get your question answered, but would still like an answer, please feel free to email me at seth.maskett@du.edu. I will send it out to our panelists. I just want to thank Katie Aker of the Scrivener Institute for all her support in putting this event together today. And thanks to our panelists, thanks to Amanda, Josh, and Ian for your very thoughtful comments this morning. And thank you, the audience, for all your questions. We have again been recording this session. Please watch for it over the next few days on the Center on American Politics website. That's du.edu/American Politics. But otherwise, everyone just have a great day, stay safe, and thank you for participating this morning.